What happens when material, non-public information no longer lives in a data room or in an analyst's inbox, but inside an AI model itself? That used to be a hypothetical question, but it's now a real issue for trading firms, regulators, and anyone trying to build or deploy AI in financial markets. By 2023, nearly the entire derivatives industry had adopted AI in some form. By 2024, almost 90% were using generative models internally, and by 2025, major asset managers reported widespread use of agentic AI tools across multiple functions. We've moved far beyond experimentation. We're now living inside an AI-driven market. Then along comes the SEC settlement with Virtu Financial. On paper, it looks like a straightforward controls case, but once you see how firms are training modern models, the case starts to look like something much more consequential. The commission alleged that from early 2018 through April 2019, virtually all employees in Virtu Americas could access granular post-trade customer order flow through a shared login, despite public claims that strict information barriers existed. The final judgment included an injunction and a $2.5 million civil penalty. As an enforcement matter, this was a familiar territory. Protect client data, prevent misuse of MNPI, maintain proper controls, nothing creative, nothing exotic, not necessarily a tie back to AI. But here's the problem. Markets today are saturated with AI systems that train on the exact type of data at issue in Virtu. Order flow, trade data, client execution history. When that information enters a model's training set, what exactly is the firm holding? Is the model itself a vessel of MNPI? And if a trader consults that model, is the firm trading on the basis of MNPI, even if no human ever saw the underlying data? That's the frontier that we're living in right now. Modern models are opaque. They learn from vast data sets. They generalize, they repurpose patterns in ways even their creators cannot always explain. And they do not record which specific data points influence a particular output most of the time. If MNPI is included in the training set, several questions follow. The first is provenance. You cannot point to a particular trade signal and say which confidential input caused it. This complicates any use analysis under insider trading law. Second is timing. Information that is obviously non-public in January may be stale by July, but if the model trained on it in January and still uses that learned pattern, is that pattern still MNPI? And then third, inference. A model may infer highly sensitive insights from harmless data points, even if it never ingested MNPI directly. So economically, the output can feel like MNPI, even if the legal definition does not fit neatly. Traditional doctrine assumes clear informational flows, and AI kind of breaks that assumption. The Supreme Court's classical and misappropriation theories still govern. Under the classical theory, an insider breaches a duty owed to shareholders by trading while aware of MNPI. Under the misappropriation theory, someone entrusted with information misuses it in a deceptive way. Tibber-Tippee doctrine also remains in play, as reaffirmed in the Salmon case. Add the SEC's win in Panawat, where a jury accepted the idea that using MNPI about one company to trade a peer company can be actionable shadow trading, and now place an AI system in the middle of that structure. Imagine a broker-dealer's proprietary desk uses an internal model trained in part on client order flow data. The model generates signals that traders act upon. Even if no one had direct access to MNPI, the firm may have reintroduced client data into proprietary trading. That is the Virtu problem, updated for 2026 and beyond. The law doesn't really need to change to reach liability. Section 15G says that misleading statements and internal control failures already cover scenarios like this. The difficulty is evidentiary. Regulators are going to need to show that the model's output was meaningfully influenced by MNPI. But Panawatt shows that juries can accept probabilistic narratives when trading patterns and internal architecture support the theory. The larger challenge appears when models approach autonomy. Regulators have already studied AI-driven trading agents that independently discover manipulative patterns. One experiment showed that an AI system learning a pump and dump style strategy simply from feedback in a simulated environment. The model did not have any human intent, it simply optimized its reward function. When the simulation removed price impact, the behavior disappeared. This raises real questions. Market manipulation requires intent to create an artificial price, and insider trading relies less on intent, but still depends on identifying who acted on MNPI. If a model decides when and how to trade, and the humans simply approved the strategy beforehand, who is responsible? And when does MNPI influence dissipate enough to become legally irrelevant? Now add vendor models built from vast data sets. If a vendor trains a foundational model on sensitive client trading information from multiple customers, has the vendor misappropriated MNPI? Obviously depends, but can the client be held responsible then if they rely on that model for their own trading? These are not edge cases, they are emerging realities. Probably the closest analog is the explosion of alternative data over the last decade. Firms were expected to treat data vendors as extensions of their own compliance environment and evaluate whether datasets could contain MNPI. The same logic should apply to AI models and their training, but at a much larger scale. Training data needs governance, cutoff dates, scrubbing, documentation, disclosures, clarity on what enters the pipeline and the output data. It all needs safeguards. Even sharing position information to help a model fine-tune can raise confidentiality concerns. Privacy scholars have noted that traditional consent frameworks tend to collapse under the weight of modern data repurposing. They recommend collective negotiation mechanisms and new forms of data rights that contemplate AI and the massive data sets that they ingest and the repurposing that happens on the back end. The same concepts may become necessary for institutional training data. The SEC's early AI MNPI cases will likely resemble Virtu, a mismatch between what firms claim publicly about the information barriers and what exactly happens inside their model and its development pipelines. Failures under 15G, weak controls under Section 204A, poor documentation around MNPI exposure in training data. But the bolder theory, still untested, would treat the model training itself as a misuse of MNPI, even when no human ever sees the underlying data. That would force courts to decide whether a model can function as an insider. We may reach a moment where AI systems are training, surveilling, and trading, while regulators increasingly deploy their own AI systems to monitor them and monitor the training of those AI systems. AI versus AI in the enforcement landscape. Virtu reminds us that order flow data and MNPI has to be protected. We need to be careful of where this information goes. And the new question is how to apply that principle when the information no longer sits in a database, but is embedded, learned inside an AI model. The law hasn't really fully answered that question yet, but the technology is here, so we'll have to see what happens next. My name is Braeden Anderson. I'm a partner at Gesmer Updegrove. If you found this analysis helpful, please subscribe down below for more insights at the intersection of financial markets, regulation, and AI.